Marilyn Manson is facing several lawsuits against him based on allegations of sexual assault. Most of those lawsuits filed recently. Let's talk about his first line of defense, the statute of limitations. What is a statute of limitations? It's a period prescribed by a legislature that says you have to file your lawsuit within this time frame, and if you don't, then the defendant can raise that as a defense and have your case dismissed, regardless of the merits. Whether it's a good case, bad case, it doesn't matter. If the defense can show that the case was filed outside the statute of limitations, the court will throw that case out. So the statute of limitations is of critical importance to every attorney in filing a lawsuit or defending one. They can range from 1 year, often the case in defamation cases, to up to 10 years, which we will discuss in a moment in these cases of sexual assault. Why do you have a statute of limitations? What's it for? Why not just let people bring cases? If they don't have the evidence, eventually they're going to lose anyway. The statute of limitations exists on the theory that we need to encourage plaintiffs to bring their lawsuits in a timely fashion before evidence is disposed of while witnesses are still fresh and available, and so people can move on with their lives. Why should people have to worry about getting sued for something they did 20 years ago? Maybe they would have a good defense to that, but they didn't keep their records, evidence, etc. So the idea is there's a value to encouraging and essentially forcing these lawsuits to be brought in a somewhat rapid fashion, depending on what the kind of lawsuit that it is. The downside to that, of course, is that for whatever reason, a person may not bring a meritorious lawsuit in that time frame, and the lawsuit gets thrown out, even though the person was right in that the injury that they say happened at the hands of the defendant, and the case gets thrown out even though it has merit. So there's a balance there. So on one hand, it is a sword that defendants use to get cases thrown out even if they have merit. It's also a shield to prevent defendants from having to keep their records, potentially find witnesses that are from a long time ago, and defend cases that are so old that you just don't have the ability anymore to bring your full defense to bear. So what's the right answer? How long should a statute of limitations be if we're going to have them? The right answer is there's no right answer. It's whatever your government decides it should be based on the input it gets from its constituents. So every state can have different statutes of limitations for the actions they have, and the federal government has its own for federal claims. Let's look at California and the cases that are involving Marilyn Manson. Generally speaking, you can see here the time to commence an action that involves assault, battery, or injury. It's 2 years. So if sexual assault were covered under this, if it occurred and you do not file your lawsuit within 2 years, even if the assault occurred, even if you have a video of it, even if the defendant signs a confession about it, you can't bring a civil claim for it. It's too late if it were covered under the statute. However, in 2019, California changed that, and they created a sexual assault statute of limitations. It basically says for adults, people over 18, that those claims can be brought within 10 years from the date of the last act. Or they incorporated what's called a discovery rule, within 3 years from the date the plaintiff discovers, or reasonably should have discovered, that there was an injury or illness resulting from an act, attempted act, or assault. So before the statute of limitations changed from 2 years to 10 years, you may have been in the last couple of years thinking, I think I could bring a lawsuit against person X. Person X, in this case, let's say, is Marilyn Manson, but I can't because it happened too long ago. And then they make this change to the statute. Does that help me? You go down to subsection C. This section applies to any action that is commenced on or after January 1st, 2019. So I want to file my lawsuit in 2021, just slightly less than 10 years, say, after my allegation of abuse occurs. Hooray, I'm back in the game. But if you did think that, you're in for a disappointment. California courts, in the case of Davis versus Superior Court, told a plaintiff looking to apply a new statute of limitations, stop looking in the dictionary at the definition of the word any, bro. Any doesn't mean all. Get your head in the clouds. Any can mean any except for actions that had already elapsed. They base this on some other statutory construction and various arguments, logic, etc. However, bottom line is, unless the legislature specifically attempts to revive past claims, they won't imply that intent. So the any claims just means fresh claims and not claims that had already been barred by the statute of limitations. Ashley Walters suffered the dismissal of her lawsuit on the basis of this doctrine, with the court specifically citing the Davis case when it says, further as to plaintiff's third cause of action for sexual assault, the recent legislation that amended the statute of limitations for sexual assault to 10 years does not apply retroactively to save plaintiff's claim. Walters had one more chance to save that claim, though, because the California courts have recognized a doctrine, and now it's in the statute, show it here, called a discovery rule. And it basically means that if you couldn't reasonably have known about what had happened, that there was an injury, etc., they will toll the statute of limitations. They will not begin to count the statute of limitations until such time as you reasonably are aware of that. However, to avail yourself of this exception to the statute of limitations, this tolling, you have to plead facts in your lawsuit sufficient for the court to be able to say there is a factual issue here that perhaps this exception applies. The judge said she did not do that in this case, so her case was dismissed with prejudice, which means she cannot bring it again. Now, the law is nothing if not confusing. So in a similar case, Bianco versus Manson, the opposite result occurred. We already discussed the discovery rule, and it would take a specific set of facts to say, I didn't know I was injured from a sexual assault that occurred quite a long time ago until recently. It could be pled, but that would take a very specific set of facts. So the court looked at the Bianco case and said, hey, same reasoning as this other court. The 10-year statute of limitations is not available to you because it does not apply retroactively. This was in federal court, federal case. But on the state causes of action, the federal court will apply the state law typically. And that's what they did in this case. And they said, nope, the 10-year statute of limitations does not apply. However, there's another exception called equitable estoppel. Equitable estoppel is basically a fancy way for the judge to look at a party's conduct, the rule that the party is trying to invoke, and then go, yeah, no, I don't think so. No, I'm not letting you get away with this. So equitable basically means fair. Estoppel is a doctrine that says that based on the prior conduct of a party, that court will not allow them to benefit from something that would go against that course of conduct. I guess what I'm trying to say here is, let's say in the case of a statute of limitations, somebody assaulted someone, and then that person ran and stayed up in the hills, unavailable to be identified for a period of time until the statute of limitations ran. Then they came back to town and go, hooray, I don't have to worry about being sued for this. I'm the person who did it, etc. The court can look at that and say, your behavior was the reason this person could not sue you. It's your behavior. I'm not going to let you take advantage of that. The statute of limitations is tolled until they could reasonably find you in town. Maybe someone was drugged when they were sexually assaulted and didn't learn about the assault for a period of time. And that behavior by the defendant to cause the plaintiff to not be able to identify the injury for a period of time could also cause a tolling of the statute of limitations. Also, if you're threatening somebody credibly, I will murder your whole family if you file this lawsuit within whatever the statute of limitations is, 2 years, 10 years, or whatever. I will kill everyone if you file this lawsuit. And it's a credible threat. So you wait until that threat is gone. The court can't say, no, I'm not going to let the defendant take advantage of that. That would work in unfairness. That's inequitable. So we're going to stop them from pleading the statute of limitations successfully in this case. So the court in the Bianco case took the position that the amended complaint adequately alleges Warner engaged in unconscionable acts that could have caused the plaintiff to refrain from instituting legal proceedings against him. Now, obviously, Manson and his attorneys say, no, that's not the case. There was a reasonable time she could have filed this lawsuit. She didn't do it. She waited almost 10 years after allegedly contact had ceased in 2011, 8 years after her last contact at all in 2013. The court says, no, the effects of the alleged unconscionable acts and when they ceased are matters of fact, and they're not to be determined by the court at this stage as a matter of law. In other words, they're not so clear the court could say for certainty whether those were a real deterrent to her filing the suit or not, but that they are pled as facts in the case. So whether defendant threatened the plaintiff and when the effect of those threats ceased, and whether the plaintiff acted within a reasonable time, those are going to be fact issues. The court says a reasonable jury could find the effects of the alleged unconscionable acts, including the perceived threat to her safety, immigration status, career, persisted years after her last contact with Warner. So the court said, yeah, you don't get this 10-year statute of limitations. The discovery rule is not in play here, but we're on the exception of equitable estoppel. This case goes forward. Motion to dismiss is denied. We'll also mention that because that case is in federal court, because there is a federal claim in it, there's a human trafficking federal statute, and Bianco brought a claim under that, so that gives the federal court jurisdiction. The statute of limitations for that claim is 10 years, so that was not an argument in this case. The final case, Ashley Smithline versus Marilyn Manson, the statute of limitations has not come up as any motion to dismiss or been decided on in any way. However, you can see from the excerpt here, the lawyer is trying to invoke the discovery rule. Ms. Smithline took years to understand the extent of the abuse. True extent of the injuries were not fully realized until fall of 2020, less than 3 years before the suit was filed, which works out great timing-wise, when she began meeting with other survivors of Mr. Warner's abuse. And just in case you're not getting where he's coming from, the attorney alleges in paragraph 48, because Ms. Smithline recognized the unlawfulness of Mr. Warner's actions and the extent of her injuries after these meetings with survivors in the fall of 2020, the statute of limitations period for her causes of action were told and are timely. That's not an order or a conclusion, that's an allegation by the plaintiff's attorney, but he is certainly getting his point across clearly. This case is in federal court now too. It has a human trafficking allegation in it, I believe. It has been ordered to mediation, so the case is essentially on hold for quite a long period until the parties report back on that process. So if you think you have a claim against someone, you've been thinking about getting a lawyer to pursue it, you ought to see from this discussion that waiting too long can have fatal results for your lawsuit. Likewise, if you're a potential defendant, just because you think the statute of limitations period has passed, you're not necessarily home free. Exceptions apply. I hope this discussion has cleared up a little bit about what statutes of limitations are, how they work, what some of the exceptions are, how they can apply in just about any case, and how they have applied in these Marilyn Manson cases.